This is Ace Livingston, and you're listening to 103.5 FM, WNHH.
I wanna dance all night, Monday morning, and I'm sick of this job already. When Tuesday gets here, I'm already hoping for the hump day. Wednesday night, calling my girls, making sure our plans are still tight. Thursday brings a smile, cause I won't be putting up with this bull in a little while. Me and my girls, we turned it up last week. Boys love this club cause welcome. Good morning. This is Babz Rawls-Ivy. We're back in pocket. Whew, I just had a wonderful conversation with Takesha Everett. It was a wonderful, rich conversation about health equities and the nonprofit that she runs, Health Equity Solutions. And now I'm getting to sit here with Jeffrey Forte.
That's correct, Babz. Good morning.
Good morning.
Thanks for having me on the show.
Oh, it's my pleasure. He is an education, law, and child advocate. And so what we're going to be talking mostly about today is the disabilities, children's disabilities, and the educational needs that have to be served.
That's correct. We're going to be talking about the individuals.
Get right close to the microphone.
We're going to be talking about the Individuals with Disabilities Education Act, otherwise known as the IDEA, which essentially is the law in which my practice encompasses, okay? And thanks for having me on the show, Babz.
Oh, it's my pleasure.
You know, I do about 1 or 2 free parent workshops every month. So this is kind of a way in which I get out to a larger audience for the benefit of your listeners. One of the most important things to understand here is that, to put into a context, we're talking about a law in which children that have a disability that is recognized under the IDEA have certain rights to access special education and related services. And if a school is not providing that access and those rights, then they are violating the law. And then you have to attempt to work collaboratively with the school district to ensure that the rights of the child with a specified disability are being implemented with fidelity. So under the Individuals with Disabilities Education Act, first a little bit about that, right? What is it? It's otherwise known as the IDEA. Okay, and it was enacted by federal Congress in 1975. And the interesting thing about special education rights and the law that developed about it is that it actually developed from the civil rights movement of the 1950s, okay, which was a seminal case called Brown versus Board of Education.
Yes.
Okay, so we're talking about Brown, right? 1950s, total different era in the world, right? And based on that civil rights movement, okay, education was found to be one of the most important functions of state and local government. So from the Brown decision, which essentially held that the segregation of public schools is inherently illegal and violates the U.S. Constitution, based on that case, other cases within disability law spawned in the 70s.
Okay.
And that culminated into what we now know as the Individuals with Disabilities Education Act.
Okay. Okay. All right. So give me an example of a disability that would warrant this conversation.
Sure. So there are about 13 or so, and they're actually identified under the IDEA. So for any mom or dad or surrogate parent that or foster parent that has a child with a disability, okay, the first thing is you need to make sure that your child gets properly diagnosed. Okay. So there's really 2 things, right? The first is the child's age. So, Babz, the child has to be between the ages of 3 and 21.
Okay.
Okay? So we're talking about that finite amount of time. Next, they have to have 1 or more of the qualifying disabilities under the Individuals with Disabilities Act. So what are some of those? Well, one would be autism. Okay? One would be deafness or blindness, developmental delay, emotional disturbance. And what do I mean by emotional disturbance? Well, children that intellectually are learning common like their typicals, but they have emotional challenges that they are unable to benefit in a general education classroom.
Okay.
All right. Hearing impairments. It could also be physical impairments or orthopedic impairments, traumatic brain injury, developmental delays such as dyslexia, or speech and language impairments, such as if a child has challenges speaking, right? And other impairments such as ADHD, attention deficit disorder, attention deficit disorder, or Tourette syndrome. So once a child between the ages of 3 and 21 is identified with one of these qualifying disabilities, and the child needs to access an education that is individualized, that is when this law then protects that child. And now they develop what's called an individualized education program, or what's called an IEP.
Yes.
Okay.
So now they
throwing
can,
a lot of acronyms at your
no,
audience here.
I'm a mother. I have four children that I adopted, and I've had an IEP for one of them.
Okay. So yes.
And we're struggling with him now.
Right.
Trying to wrap services around him. So I find it interesting. So special education can be done. It's not necessarily them taking a child out of the school environment. It is bringing the special needs services into the school. In-house, yes. Or so, depending on whatever is necessary.
Yeah, so that's a great question. So there's really kind of two directions, all right? And under the spirit of the law is that you are to work collaboratively with your local school district. So you pay taxes, you reside, you're domiciled in a certain town. Your child goes to that closest school within your district, okay? That district then has to legally, under the law, provide your child with special education and related services as required by evaluations of the school team. In Connecticut, it's called a PPT.
Yes.
Which is the planning and placement team.
I just had one of those done with like a bunch of players around the table.
Yeah. Right, yes. And the people around the table make up the team. So what's important to know is that parents are just as an important and vital part of the school team as are the administrators of the school team itself. And you have certain rights when you attend a PPT meeting. Okay. First, as you may know, since you have a child on an IEP, is that a school district has to provide you with written notice of the PPT. Okay. And everyone that attends the team, that would be the director of pupil services or the administrator of special education, the general education teacher, the special education teacher, and then any other services, related services that your child may need. So if your child has speech impairments, then you would obviously want the speech and language consultant or the speech and language therapist at the table at the PPT. Oftentimes I find that a school district may try to attempt to excuse a participant of the team without getting the parent's written consent. And you can't do that. You can't do that under the law.
See, I want to talk about some of the shenanigans because I can imagine, and I know that this kind of concept can be quite intimidating to parents.
Oh, yes.
Because it's a language that is spoken around them, but not to them. I mean, just my own experience with it. And I got a bunch of degrees and whatever. But a parent who's like different, does not have the same academic achievement can be quite intimidated by this method of around the table.
Yes.
And I got to tell you, you sit around these tables and you feel like your parenting skills come into question in ways that, I was like, wait, what's happening here?
Yes.
So,
yes.
So when did you come in?
Sure, that's a great question. So I really like to think that I'm here today on behalf of all advocates in the state, as well as all special education lawyers in the state, right? We're very supportive.
Are there many?
There are a few, yes. And we're very collaborative with each other. And whether you need to hire an advocate or a special education lawyer, some advocates aren't lawyers. I happen to be both. I happen to be a certified child advocate as well as a special education attorney. So where I typically engage and work with a client is I walk them through and empower them to understand the PPT, the planning and placement team process. So I will attend these school district meetings. And you're right, for parents, it could be very intimidating. You're talking about up to 10 people
in a room
on the school team, and then you have mom and dad, or sometimes just mom, where they're listening to information that's being provided to them. They're getting documents that they're reading for the first time, and trying to listen at the same time. And it can be quite intimidating. That's why I always advise the people that call me and my clients that you are entitled, if you request it in writing, to receive any and all documents, any and all proposed goals and objectives. So for parents that are on that have a child on an IEP, you know what I'm talking about, and draft IEPs 5 days in advance of any meeting. And a lot of parents just don't know that. So you can actually
I didn't know that.
Yeah. So
Honestly, I didn't know that.
And it's important. A lot of parents don't realize that you can do that. The other thing is, in Connecticut, you are legally entitled to record a planning and placement team meeting when you're discussing your child's individualized education plan, the IEP. And a lot of parents don't know that either. Well, as a best practice, if you do plan to record a PPT meeting, what you want to do is you want to let the school know in advance.
Yes.
Okay. And the law in the state of Connecticut actually protects a parent to record a PPT under certain conditions, which then could be elongated and interpreted into other means. The first is if the parent has a disability themselves that impairs their ability to fully comprehend and understand what's going on at the PPT meeting. So if you have a hand impairment that allows you not to write well or write fast, or English is your second language, not that that is an impairment, but if English is your second language and you don't have the communication ability to fully understand what's going on, the case law in Connecticut supports that you have the right to record the IEP. So now you can go home at your leisure and listen to it again and again to be a more collaborative, collaborative is the key, member of the PPT team.
But when people call you, Jeffrey, they are really up against it at this point, right?
Yeah.
Because the idea is to not have to call you to get something resolved or get heard or get services or whatever.
That's right. That's right. So typically when I'm getting involved, Babz, the spirit of collaborating is gone awry, right? The school team and the parent team, there's some friction and possibly some hostility going on. And I have to engage to determine whether or not we should be re-collaborating with the district or if we should be seeking it through the formal legal process, which is called due process.
So you're not coming in just like, okay, this is what we're going to do. You have to spend a little time and see what's happening.
Right. So a lot of the reasons why I would be called, really for an initial consultation, initial appointment, I'm looking for things like, is a child being denied a free, appropriate public education? And we get into what the acronym FAPE means, free, appropriate public education. But other things is the child being provided with an education in the least restrictive environment, otherwise known as LRE. You can't, without the consent of the parents, and under the law of the IDA, you have to educate a child with a disability in the least restrictive environment because they have to be able to socialize and generalize and learn with typical peers.
So you can't just wheel them down the hall or put them in some room by themselves, or
not at all. That would be that would be
because they used to do that.
They did. And that's we have a lot of unfortunate history in the United States about that. That would be restraint and or seclusion, and that actually also violates the law. But the other reasons would be, more kind of day-to-day challenges would be if a school district has reduced or denied the number or the hour of services that a child is receiving. So if you have a child that has physical impairments and requires physical therapy, and occupational therapy, which, by the way, is a related service that your child is entitled to should they need it, and those services are reduced or denied, well, that would be another reason why you would need to retain a special education lawyer or a certified child advocate to advocate back or to initially get those services. Another important milestone to remember in a child's education tenure is that when a child starts to become at the age of 14 through 16, under the law in Connecticut, a child has to have a transition plan at the age of 16.
What does that mean?
So a transition plan is, how do we transition this child to have a beneficial outcome after high school, right? What are their goals and objectives? What type of occupation do they want to have? And if we're talking about a child that has impairments and disabilities, we have to get, technical and focused on that. And if a child is not being provided a transition plan, that would be a violation of the free appropriate public education.
So tell me something, Jeffrey. Do schools know they have to do this?
Well, yes, they do. They do. What you would typically start is, if a child has disabilities before the age of 3, if the parents recognize that, typically what they do is they get involved with birth to 3 services.
Yes, we had that. My son arrived with no ability to speak.
Right.
And he didn't really speak till he was about 5.
Right. And, moms always know best, in my opinion, right? So once you've realized that there is a developmental delay, a milestone challenge, and you do get your child diagnosed, under birth to 3 services, which is, income contingent and so forth, most likely what happens is a child is emerging into pre-K within their local school district with services that are being recognized. The unfortunate circumstances are when a child is just not found to be eligible. And
what does that mean?
Sure.
So you mean to tell me I'm the mom and I say, well, this is what happened to me. I said, listen, this child is not speaking. I think there's a problem here. And they said, well, maybe he'll grow into speaking. All children are different. Wait and see. And I was like, no, I can't wait and see. He's 3. He's not speaking.
Yes. So
I had to, you know what I mean? See the push I had to do?
Yeah. So under the law, there is a proactive approach in which a school district has to find children. It's called the child find clause. Okay. And under the child find section of the IDEA, a district has to proactively find children that may be suspected of having a disability. And they can even request initial eligibility, and let the parents know that we feel that there's a problem. But typically what happens is a parent will notify the school district that they feel that there's some services going on that they need. And then that's when the initial evaluation starts.
Yes. Okay.
But, there's other reasons, too, in which you would need to seek out legal representation. If a child is being overly disciplined at school, okay, which is a whole
and this is a big deal right now.
It's a really big deal right now, especially with everything that's going on in the U.S. If a child we're talking about a child that is protected under an IEP, that has an IEP, and if they have behavioral challenges, and what do I mean by that? They're getting suspended at school. They're getting disciplined. They're being sent to the principal's office over and over and again. The law, again, on a proactive measure, on a collaborative measure, qualifies that child to be evaluated for a behavioral assessment. And the acronym for that is an FBA.
So you see how parents could get lost, right?
There's thousands
in Alphabet City. We could just get lost.
Yeah, I actually have an Alphabet Soup blog on my site. But an FBA is a functional behavior assessment. And it looks to identify what are the triggering behaviors, what are the triggering events that are making the child act this way. And typically what happens is, if those behaviors are interrupting the other students or not enabling the child who is misbehaving to access their own education, then an FBA typically is warranted.
Is it ever a good idea to take children out of a classroom in handcuffs?
No, not at all.
That happened to my friend.
Oh, really?
7th grade, her son.
Really?
Taken out of the class in handcuffs.
Well, if
I'm gonna give her your number.
yeah, it's
because I don't think she knows.
Yeah, and children have rights if police are called to the school as well. You have
Do they?
Yes, you have to call the parents, and if the parents should
Really?
come down before the child is interrogated or questioned by the police. You have to get the parental consent if they're under the age. If they're young. Yeah.
But I never see. But we never see that, right? Like I never see that part. I always see.
Right. Typically, what happens is the police department may be called as well as 911 and ambulance services. And I have cases in which those incidences occur, and especially with everything that's going on right now, things could be misinterpreted, especially with the heightened scrutiny that we're all under right now, and school administrators as well.
Yeah.
They're looking to protect other children that are in the school, obviously. So
And I understand. I mean, I guess I do understand it. So Jeff, how do you do this work? Like, how do you?
Good question.
How do you come to this work?
Well, I have a lot of personal history with representing kids. I used to work at two of the largest law firms in the state, and I did a lot of pro bono work. I really enjoyed doing this. My wife is also in the field clinically as well. So, it's something that I've always done, but really now have been exclusively focusing my practice on this, frankly, because there's a real need for this, Babz.
That's what I was getting at. Like
there
seems to be a real need for this.
Yeah. And as parents become more educated and empowered with listening to examples like this, right? You start to understand more about the IDEA. Figuratively speaking, the law is actually a pretty, fairly new law. It's only been enacted since 1975, and then restated twice since then. And there's other laws within it that have actually become kind of concerning. In the 2004 provision of the IDEA, if a parent files a frivolous action that has no merit, kind of like intentionally just to shake the tree against a district, and the district wins, arguably that district can sue the parent for the school district's attorney's fees. Now, does it happen often? No, but there is a provision in the IDEA that protects that, so parents cannot bring a frivolous action. So typically, if a parent's already filed for due process on their own, without legal representation, you're really just kind of going in blind, and you shouldn't be doing that. You want to make sure that your due process action has teeth and merit, right? But some of the related services that we're talking about are important to know, because we're not just talking about education in and of itself. We're talking about the services that support the deliverance of special education. So what would those things be? Most common, transportation, right? Transportation can be just as expensive, if not more, than the special education placement of a child with a disability.
Well, we're having this, I'm in New Haven, and the Board of Ed is having this conversation now about how much money, millions, that are spent in transporting children all across this city, right?
Right.
Millions.
Oh, it's very expensive. And the issues that are involved with that is, if a child needs more than just your typical bus, the school district is obligated to provide that specialized transportation as a deliverance of a related service under that child's individualized education plan. So what examples would that be? What have I seen? Well, if a child has a physical impairment where you need a ramp to access a van or a bus, let's say a child has a disability in which they need to have air conditioning on the bus, otherwise they have a physical issue, then that bus needs to be air conditioned.
Wow.
Let's say you have a child that bolts and escapes and evades. You may need a paraprofessional
To be on
to
that.
sit with the child on that bus,
Mhm.
door to door, with a log and video.
Really?
Yes, absolutely. So these are all things that you have to really advocate
I am getting a
for.
real education because I had no
Yeah.
idea.
Yeah, and you really do have to have a plan as to what you should be seeking from your district at a PPT meeting.
Mm-hmm.
But the other things too, parents often misinterpret that parent counseling is something that is also covered. So it's not just related services for your child, but it's related services for you as the parent of the child. And what would I mean by that? Well, let's say you have a child that you have a son or daughter that really has some challenging issues, and you're just not really aware of how to handle that. Well, the school is obligated to provide you with counseling.
I've never heard that.
So that is to ensure that the services,
You know what I'm gonna do tomorrow. You know I'm gonna do Monday, right?
you see counseling, yeah. and
March right over there.
that really gets into this aspect of generalization.
Mm-hmm.
Okay, so if a child is being provided with services at school, how are those services generalizing into the home environment, and how are those services generalizing into the social and community environment?
Oh, that's
And
interesting.
that
That
is
seems like a
what-
lot of work for a school to do.
It does, and that's why they often
Don't do
will-
it.
Well, yeah, that's why they often don't do it. But also, they may seek out private services that then are paid for by the school district, which really kind of gets into another thing, and that is called an independent educational evaluation. So, have you ever heard of what an IEE is?
Yes.
Acronym IEE.
Mm-hmm.
Okay, so an IEE really is it's a public policy aspect of the IDA in which it allows for a parent to, on some level, have an equal playing field with the school district. So an independent educational evaluation is typically requested when a parent disagrees with a school-provided evaluation. So we'll put it into context. You have a child that has physical impairments as well as significant speech delays, right? But intellectually can progress just as common as the other typical students within their classroom, okay? And the evaluators say, well, we think we're only going to provide your child with a half an hour of physical therapy a week. Or we're not going to provide your child with physical therapy at all because we feel that they're about to be making continuous milestones. If you disagree with that PT evaluator's report, then under the law, your protection is that you have the right to request. You don't have the right directly to have it done, but you have the right to request that an independent educational evaluation, in this example, a PT independent evaluation, be conducted.
I don't think parents know any of this.
Yeah, a lot of parents don't.
I don't think parents know any of this.
They don't.
You should be speaking at PTA meetings all over the state.
Well, I gave a presentation once, and we had about 50 people at a city hall, and I stayed for about a good hour and a half after the program, Babz, because there were just so many questions I couldn't just walk away from not answering. But with an IEE request, a school district under the law has two options, and only two options. And it's important for parents listening to your program here to know that. The school district either has to grant your request or bring you to due process,
Okay.
explaining to an impartial hearing officer why their evaluation is correct, and the parent's request for an independent evaluation is not needed. So this is where parents often struggle with navigating these waters, because if you request an IEE without the reasons for knowing and prepping for that, you could very well be facing a due process action quite
Really?
Yes, and the school district and the school district attorney will then be bringing you to due process to explain why their evaluation is correct and your evaluation is not needed.
But that doesn't that supersede what the parents want?
It does. It does. So that's why when you hire a special education lawyer, you're looking for reasons why to support why an independent education evaluation is needed. And under the law, you technically don't need to explain yourself as a parent why you are asking for one in the first place. But typically what happens is you start to negotiate this process and try to collaborate on a mutually agreeable evaluator that is not employed or paid by the district. The district pays for the evaluator, but they're not on the payroll of the school.
Okay, I see.
Okay.
I see.
So that it tries to make it an even playing field. So we're coming in with an independent evaluator that isn't necessarily on the school district's payroll, but also isn't necessarily exclusively for the parent. And we're collaborating to get an evaluation done separate from what the school district is providing.
Wow.
And actually, just as about a couple weeks ago, the Bureau of Special Education for the Department of Education of the state of Connecticut issued 13 or 14-page guidelines on IEEs, and there was a task force that was created about how school districts should be implementing best practices about IEEs. And some of those guidelines, which interpret the provisions of the IDEA, indicate that a parent's IEE request must be granted or denied without undue or unreasonable delay. And they propose and recommend that that time frame is 10 days upon which the parent has requested it. Now, that time frame could be extended if you're now starting to negotiate and collaborate who would be that evaluator. Okay, but if the school district isn't simply getting back to you within that time frame, I would submit to my clients that time frame now has been passed, and now you should be seeking and going forward with your own evaluator and telling the evaluator that the school district's going to be paying for it since they just did not get back to you.
So are some school districts better at this than others?
There are, and it really depends, where you are in the state. There's also the issue of that there is a lot of turnover, Babz, within education generally. The average tenure of any particular director within a district, I believe the reports and evidence indicate that it's about 5 years.
Oh.
Okay? So you as the mom or dad are really the only forever permanent present advocate, right, for your child.
Yeah.
And that's why it's important. One thing that I always tell my clients, it's important that you create a binder. Okay, so let's talk about that. Let's talk about how if you do need to retain an advocate or a lawyer, what you should do to, number one, make it, cost efficient, but also so the lawyer or advocate can also absorb and get up to speed just as much as the parent is in a quick fashion. And that would be by creating a binder. And that binder should really be in a chronological order with the beginning services from all the way back to perhaps birth to 3.
Jeff, where were you a decade ago when I needed this information? But it's gonna help somebody else, though.
Well, yeah, I was working at one of the largest firms in the state. I've done lots of different types of litigation. I come from this approach a lot different. I've negotiated for a number of years. I've done lots of large litigation, but at the heart of it, one of the reasons why I actually went to law school is really because I'm about representing the individual and representing families, and this is such a rewarding practice because you get to make a difference one child at a time.
Okay.
All right. Yes, just yesterday was a great day because I had a child that was not otherwise getting the services that he needs and actually was home from school for 6 months.
What?
Privately outplaced to a private school that the district now had to pay for. And it's a very reputable private school, a school for children with autism that now he's getting the services that he needs. And that's really what it's about at the end of the day, is making a difference one child at a time.
It just seems like parents have to fight so hard to get what is needed. Like, I just keep thinking this ought to be an easier, friendlier process. Like, I'm just trying to get my kid educated so that they can be productive people.
Right. They should.
I'm not trying to take anything that isn't mine, right? Or for him to have.
Right. You're simply asking for what your child is entitled to under the law. And that's what I always make sure that parents know. But on the flip side too, not to paint a bad or difficult picture of school districts. I like to think genuinely at the heart of the matter, Babz, that anyone that is in the field of special education, whether it's for parents or on a systemic level and working for a district, they got into this field because they genuinely care.
Yeah,
okay?
I agree with that.
And I would say that's about 99.999% accurate. Right? What happens though is when you get a volume of students that need these services, and then you get reduced funding, and you get the state that we're in with state budget cuts, which by the way completely are irrelevant. Okay, a school district cannot say, well, because of budget cuts, we need to reduce your son's or your daughter's specialized education. That is actually illegal.
Really?
You cannot do that.
Oh.
Okay? It has to be to their needs, their tailored needs. It can't be based on the lack of funding. Okay? But what happens is, children get lost in the system. So that's why you need someone that's kind of forever present. And that typically is the parent. But when you engage a lawyer like myself, you now have somewhat more of a even playing field in that process as you progress in the special education process.
So talk to me a little bit, because we got 20 minutes or so. Yeah. I saw something in your bio, in your professional bio, about bullying and that kind of thing. Do you handle what is that like? Talk to me about what that looks like.
Sure. So bullying is something that actually I think it's getting worse rather than better, and there are guidelines around it. Bullying, I think, is getting worse because especially now you have social media.
So when do they call you for the bullying?
Sure.
Like, what do you get the call about?
Yeah. So I'll typically get a call where a child refuses to go to school because the bullying has gotten so severe that it's causing them anxiety about even going to school. And the anxiety that is being caused isn't necessarily anxiety that's being caused on the brick and mortar of the school ground, but rather is being placed on social media about what may happen at school if the child goes to the school.
Oh.
Okay. Now, although the bullying is occurring off school grounds, if it is affecting the child's ability to access education, then that is a qualifying event that your child is protected under the bullying rights of Connecticut.
Oh.
Yeah.
So what do? You come in and do you?
Well, a couple things. First, you have to file a bullying report. Okay. Yeah, you have to file a bullying report, and that would lead to an investigation that the school district is obligated to provide you with.
Oh.
Now, do school districts always provide an accurate one? And kind of just summarize it as it being mean-spirited behavior. Mean-spirited behavior is a buzzword because under the law, if the action doesn't qualify for bullying but just qualifies as mean-spirited behavior, then there's no bullying. And then there's no incident of bullying.
Okay.
Okay. So
that's their out.
Right. So certain examples, right? I've seen it where a child is choked on a bus, and the investigation report just says, yes, it was mean-spirited behavior, which under the law, any physical altercation automatically is bullying. So how could a district determine that to be mean-spirited behavior? So then you could reopen the investigation and disagree with the outcome of the bullying report. But it's interesting to state that I see both sides, Babz. All right, I see and represent children that have been bullied and children that have been bullied that qualify under the Individual Disabilities Act. They're actually being bullied because of their disability.
Okay.
Okay. But then I've also represented and actively now am representing children that are the bullyee, the bullier, the child doing the bullying, but they are also protected under the Individual.
So what do you do with
Disabilities
that?
Act.
Do you talk to the parents? I mean, what happens?
Sure. So in a lot of cases, a child can get suspended. They can get expelled. The school district can seek outplacement. And if the district failed to adequately and with fidelity identify what the child's behavior and the reasons for that is, then that is an issue. That is an issue that could lead to a violation of the Individuals with Disabilities Education Act. Gets into what we were talking about how you would retain a specialist that analyzes a child's behavior called a board certified behavior analyst, okay, or a BCBA. And I actually happen to know quite well a board certified behavior analyst that's also has her PhD in applied behavior analysis. So you would want to have those services engaged to determine, why is this child acting out? For example, if a child has auditory challenges, okay, they hear things differently than you and I. They hear things differently than a typical child. And when the bell goes off, okay, for change in classes, that causes them to have anxiety, or it just resonates in their head so much that they have sensory processing disorders, okay? And then they start to throw books around. Well, it's not that they're misbehaving for misbehaving's sake.
I see what you're saying. Something is causing it.
Yes, they're misbehaving.
That's heavy. I mean, that's a lot.
It is.
That's a lot to sort of digest.
It is. And that's why I explain to parents that in this area of the law, it's so important to have a therapist, a clinician, a psychiatrist, psychologist working with your child to the extent that your child's going to need these services. Because if there is ever an issue where they are arrested for something that may have been misinterpreted because they don't have a proper social filter. Okay,
Oh, well, we've seen that.
you know, or you know, something happens on school grounds. It's important to have these experts, just like with any case. You know, you need experts in order to explain why something happened. And with my practice, I know lots of experts across the state. So what we typically will do is we'll collaborate with the school first, right? Because that's really, after all, what the spirit of the IDA is. And come to the table with our concerns. And that's really what you want to do first. All right. Typically what happens, though, is the parents have already done that. And it's not working. So now that's when you bring an advocate or a lawyer to the table to get the services that you were originally requesting.
Wow. Okay. So if y'all just tuned in, we're about to bounce out of here. I'm Babz Rawls-Ivy. This is Lovebabz, Lovetalk. I'm talking to Jeffrey Forte, Esquire, Education Law and Child Advocacy from the Forte Law Group. This has been a really illuminating conversation around this language that I don't think parents just know.
Yeah, you know, a lot of parents really aren't familiar with it. And what I do actually, on my Facebook page, I am committed to putting on at least 1 or 2 free parent workshops a month. And what I'll typically do is I'll hold them at local libraries. I have one coming up at in Norwalk pretty soon as well. And really just educating parents, because the more that I can empower parents about this field and the more they can advocate on their own, if they're not getting anywhere, I now know and can immediately jump into a matter. The other thing that's important to know, speaking of things that parents don't know, right, is that parents are entitled to receive a complete copy of their child's education records. And that is through what's called a school records request, or what's called a FERPA request. Again, another acronym here, FERPA, F-E-R-P-A. And FERPA is Family Educational Rights Privacy Act. And under FERPA, what you would do is you would file a FERPA request. And, it sounds more intimidating than it is, but it's really simply a letter to your district saying, hello, I'm mom of son Bob Smith, date of birth such and such. He attends such school, and I'm requesting one free copy, which I am entitled to under Connecticut law, one free copy of my child's entire education records, and that would include all grades, report cards.
Really?
Yes.
I had no idea you could get that.
Evaluations, assessments. It even includes, Babz, emails that you've sent to the school and the school has sent to you, but also any emails and communication, hand notes, video written about your child, any notes among administrators and teachers and evaluators within the school district, which can also provide some interesting information if you're not collaborating with the school team and you need to find some information that is going on about your son or your daughter. So typically what happens is I engage the school by filing this school records request on behalf of the parent. Now, under the law, you have certain time frames in which to receive those records back. Depending on when and the timing in which you're receiving it, it's anywhere between 5 and 10 days.
That fast?
That fast.
Wow.
And if you request it annually, what you want to do is you want to continue to get the records year over year, and you're entitled to get those records supplemented free of charge.
Wow. I've learned so much, Jeffrey. Thank you so much for coming. I'm so glad that we got a chance to do that. I hope you come back.
Thanks, Babz.
Because this was really good and very illuminating. And I don't think people know. Listen, I consider myself well-read, a smart person. And I do my due diligence. But I just learned some stuff today that I didn't even know. And I got 4 kids.
Yeah. It's important. It's really important. And it's great that you have programs like this because the mission is really to empower parents to handle this. And also, there's an event coming up that I would just like to let everyone know. It's called Seek of Connecticut, and I'm on a committee to help promote that program called Seek of Connecticut. You can Google it and check it out. There's an event coming up in June, I believe, on a Saturday, and we're going to be having a whole slew of programs. And lastly, my site is www.fortelawgroup.com. And I have 3 office locations across the state. Shelton is where I'm primarily located, but I also have an office in Westport as well as West Hartford.
Okay, so
Okay?
you
Yeah, my practice is
got the triangle
I
going.
work in all the districts across the state. Yeah.
Okay.
Yeah.
Well, thank you so much for your time today. This was good. This was very good. Harry, I'm going to play us out, and I'll be back on Monday, but stay tuned for Pundits up in about 15 minutes.